flatly contradicts the Data Protection Directive. This is first pillar data. Yeah, it's data collected in a commercial context by an airline or its customers. It is not passed on for the purpose for which it was collected. You give the airline your information because you want to travel with them, or maybe you tell me you want a halal meal or a kosher meal or whatever. You don't do that to let the Americans know what your religion is. So this definitely could not be squared with the directive. The directive allows for the passing on of data to third countries, but only if the third country guarantees adequate protection. Okay, negotiations between the United States and the Commission, effectively the Council, they reached a deal. The deal was massively criticized by the data protection authorities, the supervisor and everybody else, especially also by Parliament, the European Parliament, who opposed it and took the case to the European Court. The European Court struck it down because it was adopted on a wrong legal basis. So in other words, the court did not address the fundamental principles about whether or not it gave adequate protection to personal data, but it just said it was on the wrong legal basis. So they had to start all over again. They come up with a new arrangement, and hey ho below, it's not maybe as bad, but it is still lousy. Instead of 34 items of data, they're only sending 19 items of data. The most important problems with it, I can't go into detail, you can find all the detail on the State Watch website. Yeah? Especially in the analysis of a chap called Steve Pearce, P-E-E-R-S, Steve Pearce of the University of Essex. Very, very good man. He knows more about this than I will ever even begin to understand. He does all the analysis, and without him, the public in Europe would not be properly informed. Really, it takes one person to consistently go through all this ghastly, detailed stuff and show up the big pitfalls in it. Very strange agreement. The agreement consists of a formal agreement plus a set of covering letters. The covering letters, going back into my international law bit, do not make clear whether they are part of the agreement. It's not clear whether they are a treaty or not. One of the strangest things is that the United States gave certain undertakings. One particular thing it did, it made the Homeland Security data subject to its own privacy laws, which was great because that's what the data protection authorities had asked for, just before this agreement was adopted. Then, a few weeks after the agreement was adopted, they then brought in an exemption which basically tore up the data protection that they had just granted. Whether the Commission has two possibilities, as State Watch puts out. Ben Hayes is the man who briefed me on this one. Either the Commission was in collusion with the Americans over this, or they were so ignorant as to be totally culpable of not knowing what policies to adopt. It really was, again, a stab in the back of the concept of the rule of law. To give the impression that you provide protection, and then to take it away with the other hand a few weeks later. Those are just a few examples. For the details, go to the State Watch website. Just to mention that there is a massive system of data collection in Europe. It's a worldwide system of data collection. It's based on a 1948 agreement between the United States, Australia, and the United Kingdom. And it is basically a massive worldwide monitoring system of all the data that float around through satellites in particular. There are some very big systems, Menhill, I think the thing is called in the United Kingdom, and there's some others. Look at pictures. If you type in echelon in Google, you'll find lots and lots of references to it. Basically, they suck up all the data that they can possibly get. I don't know if you've heard of the controversy recently in the United States about the United States authorities spying on the emails and telephone calls of United States citizens. Big controversy because it's unconstitutional. Well, the Americans have a little blind spot in their constitutional eye. And I call it the Guantanamo Bay approach to fundamental rights, which is that they believe that their constitution applies to American citizens and perhaps to citizens, residents of the United States. But it does not apply to anybody who isn't resident in the United States. Therefore, they are not at all upset about the fact that everybody who's not an American citizen or resident is being spied upon, but believe me, you are. Yeah? A hell of a lot of data is being passed on. Companies should be aware of it because a lot of commercial data, in fact, The original allegations was that most of the spying that was carried out by the Americans was for commercial purposes, to pass things on to their American companies. But these days it's also especially in the anti-terrorist field. But they do more than that. You may have heard of the SWIFT controversy. SWIFT is the banking system. Anybody who gets paid across borders should use the SWIFT system. And it's an interbank system through which they send the data on transactions from one bank to the other. But SWIFT is a Belgian-based company, but it's basically run by the banks. It's kind of federation, if you like, by all the European banks. Like many international corporations and bodies, they have databases that they mirror in the United States. If you talk to any international company, they will tell you that that is absolutely standard routine. What the United States did, they used the anti-terrorist legislation to demand access to the US mirror of the European data, right? To find out, e.g., whether any students of Arabic origin were sending money to suspect organizations in Pakistan, right? But basically they wanted all the data. That was what they demanded, and they got it. And SWIFT is being prosecuted. It's still under investigation in Germany, because it didn't only, rather the German banks are still under investigation in Germany for the same thing. SWIFT is under investigation by the European Commission, and they've just had to come up with an arrangement, which is not a very good arrangement. I'll not go into it. Basically it means SWIFT has entered the so-called safe harbor in America, which is an American-European arrangement about data transfers. The big problem is SWIFT is the exception. That's the one that was shown up. In fact, all international organizations have mirrors. And believe you me, if the United States is looking at SWIFT, they're looking at everybody else's data. I can name some companies, but I'll not name them. That I'm certain, I know, because I've worked with them, that they have big databases in the United States, and that are definitely accessed, certainly can be legally accessed, and my guess is will be accessed by the United States authorities. And all of them will be illegal under European law, and the Commission laws very little about it. Profiling, I told you about the profiling system, yeah, and how bad it is if you start trying to find out individuals. Well, it's being pushed very strongly by the European Commission and by the Council, saying not only should we do profiling, we should use each other's scores to search each other's databases. So all these databases, you have national scores and national profiles that are let loose in the national databases. They want to incorporate that into each other and make it pan-European. I'll not go into any detail, let me just say, because I haven't got the time. Data protection law in Europe is based, starts with the Council of Europe Convention number 108 from 1981 or 82, I forget. That is still the basic legal instrument that started with the data protection principle, was largely drafted by a very nice man called Frits Hondius, who was a senior official in the Council of Europe. I worked with him. Then the Council of Europe made a recommendation under the convention called R8715, which is on personal data processing for police purposes. That is still an excellent recommendation. It is officially referred to in pretty much all European instruments relating to policing and data protection. The Schengen Treaty, the Europol Treaty, they all refer to this. But the Commission would like, and the Council would like to forget about it. In the draft framework convention, it is rather played down, and in some other websites, funnily enough, you can barely find the thing anymore. But that is still, and it's going to be very difficult for the European authorities to go against the principles that are set out in that recommendation. One of the principles that it says is sensitive data. There's data on sex, race, ethnic origin, medical stuff, things like that, shall only ever be collected when it is absolutely strictly necessary in a particular case on a case-by-case basis. That means, by implication, that you cannot use those data for profiling. Yeah? Principle that is absolutely trying to bypass in the arrangements for European profiling and other arrangements.